powerful power of attorney, and why is it so important?
Well, let's start with power of attorneys in general and discuss what those are. Power of attorney is a document. Sometimes people use that phrase, power of attorney, and they're talking about the person that can take action. As we're using it today, we're talking about the actual document, a power of attorney document. So Ohio has two really common power of attorney documents that people use. One is a healthcare power of attorney. That is very important because that document, you name somebody to make healthcare decisions for you when you cannot make them yourself. So that's typically a spouse or a child. Believe it or not, in Ohio, if you don't have that document, the doctors and hospitals don't have to listen to your spouse or to the kids. They might, but they don't have to. The healthcare power of attorney is what gives them authority and tells the doctors and hospitals you are officially appointed to make these healthcare decisions. Then the other document is another main power of attorney document is a financial management document. And sometimes that might be called a general durable power of attorney or a financial power of attorney, different names for the same thing. And that document lets your agent, again, often a spouse or a child, somebody you trust, that lets them be able to manage your assets from something simple like writing checks on your account to something big like selling your house. So again, important to have. And between those two documents, one for healthcare and one for finances, that should prevent the need for you to have a guardianship, because one of the most common needs for guardianships is somebody becomes incapacitated, and before that time, they never got around to doing power of attorneys to make sure somebody could do their healthcare decisions and financial. Now the family has to go to probate court while the person's alive and ask for a guardianship, which is slow and expensive. Every time you want to use that person's money for their care, you have to go in and ask the probate court for permission. So we want to avoid that. If we have anybody that's trustworthy in the family that we could name as a power of attorney agent. So now let's talk about what makes a power of attorney powerful. So most financial power of attorney documents, if an estate planning attorney has prepared them, they're fine documents. They'll take care of managing the assets when it comes to selling something, writing checks, those kinds of things. But what they typically lack is any tools that we would need for long-term care benefit planning. So we need tools in there to allow us to move assets around, gift them, shift them, to take advantage of the Medicaid exemption so we can hold on to assets. And I'll give you an example. Is for a husband and wife, they typically own the house in both names. If the husband goes into the nursing home, we want to get the house out of the husband's name and put it in the wife's name to avoid Medicaid's lien. Now, if we don't do that, Medicaid won't kick the wife out, but they'll eventually put a lien on the house. So we want to get the husband's name off. If the husband's still competent, he can sign the deed himself. But if he's not competent, we need a financial power of attorney from him that he had prepared ahead of time. And we also need language in there that allows the house to be gifted. Now the power of attorney, a regular power of attorney, probably says she could sell it, but we don't want to sell it. We want to gift it from husband to wife. And Ohio is very particular and picky about when you can make that kind of gift. And if the right language isn't in there, then it's not valid. In fact, if the power of attorney actually says that the agent can make gifts, which is somewhat unusual for it to say that, but if it does, Ohio limits that gift to $14,000 a year or whatever the current annual exemption is, and that's not enough to gift the house. So even though the power of attorney doesn't put a cap in, Ohio does unless we have particular language in there that says we can give away more than that. And that's just one example. There's a lot of things we have to have included in a powerful power of attorney so we can do elder care planning.